taxpayers. The average cost of detaining someone for one night is $164, but it can be much more expensive when you're talking about detaining families and adults with children. There's a system made up of 34,000 beds and 200 facilities. Some are ICE owned and operated, are privately run jails and prisons. And you've probably heard of something called the detention mandate or the detention quota. Congressional appropriations language covering ICE's detention budget requires at least 34,000 detention beds be maintained each and every day in the United States. And some in ICE and Congress also interpret that language to mean that those beds need to be filled. This quota was enacted in 2007 and remains in the 2015 DHS appropriations bill. This is really the only enforcement agency in the country that has this kind of quota, which discourages the uses of alternatives. And the ABA does encourage ICE and Congress to invest in alternatives to detention, which are much more economical and are highly effective. For many years at the since I can remember, really, the idea has been to detect, detain, and deport, because there's a mentality that once people get into the United States, it's much harder to keep them out. South Texas is home to one of, I think, the largest ICE-owned and operated detention facility called the Port Isabel Detention Center. It's a 1,200-bed facility, and I was there as recently as just July, and really, I look at it now as a deportation factory. Back in 1989, when I first went down there, it was really, we deported. It was very, very rare to see someone get deported. The majority of the people would either apply for relief, they would be released on bond, some would be moving on to Canada, but today it's really the opposite. It's actually a complete opposite. Today, having someone be able to stay in the United States, get released on bond, or win relief is more rare than seeing someone get deported. Last year alone, from the Port Isabel Detention Center, there were 59,000 removals. The average length of stay at that facility is 2 to 4 days for level 1 detainees, which means detainees with no criminal history, basically migrants from Central America, especially from Guatemala and Honduras, where there are pilot projects where the consulates work with ICE and CBP to start the travel documents from the time they're apprehended while they're still in CBP custody, Customs and Border Protection custody. Detainees are removed through ICE-leased craft out of Brownsville, Texas, and there's an expectation that the vast majority of those that are picked up by the Border Patrol officers in that region will be promptly deported to their countries. And that is the mentality, and that is the detention center has increased staff incredibly. There are attorney visitation rooms, of course, but some of them have been taken over by deportation staff that are working daily and day and night to get travel documents, to arrange the flights. I mean, this is virtually a deportation factory. I want to talk a little bit in terms of more specifics on how the enforcement procedures are applied to different groups of people. For example, adults or adults with children, unaccompanied children, and unaccompanied children from contiguous countries versus non-contiguous countries. We've talked a little bit about the adults, and adults with children, they're treated equally the same. Adults that are apprehended within 100 miles of the border, within 14 days of entering the US, are subject to expedited removal. They receive the removal order immediately. That causes them to be inadmissible to the United States for 5 years. But if they fear return to their country, they can ask for something called a credible fear interview. Those are by asylum officers that travel from Houston or are on the phone or televideo. And those interviews should be held within a matter of days. It can take longer. Those who pass the credible fear interview will have the right to go before an immigration judge. But during the time they're going through this process, they're subject to mandatory detention and they don't have right to bond or parole. A year ago, or a little over a year ago, families that would come to the border would generally be released on their own recognizance. They may have reporting requirements in the cities of their destination, their final destination. But starting this summer, the administration increased detention for families, opening the Carnes facility in New Mexico, the Artesia facility in New Mexico, the Carnes facility in Texas, and now Dilley, a 2,400 bed facility also in South Texas. So there's no longer a need for ICE to release people, and they have been detaining adults with families almost across the board, although some people may be released to some of the communities. It really just depends on bed space and the day and the policies in place at that time. It's very problematic to see families detained and children for many obvious reasons. It's often traumatic, and it's difficult for even ICE to have these children in the facilities. These facilities are not meant for children. They're not equipped for children, and there's been a lot of advocacy, and you'll hear more about it today, on the use of alternatives to detention and more humanitarian ways of detaining these families, keeping track of them. Today, more than 50% of those removed are issued expedited removal orders. And this is really one of ICE's mainstays now in the country. The majority of removal orders are not issued from within the country. And this really, when people are removed and they turn around and they come back, they're subject to criminal penalties for illegal reentry. And they may be doing more time because they already have a removal order, although they may not even realize that what they were given the first time around is a removal order. I want to talk very quickly about unaccompanied children. I know that Aryah is going to speak more about the children, but children are treated differently depending on where they come from. Children from contiguous countries have the least due process rights of anyone who enters our country. Kids from contiguous countries, so that would be Canada and of course Mexico, are basically just turned around and sent back to Mexico through diplomatic channels, working with the consulates and the officials at the bridge. They are supposed to be screened by Border Patrol agents and screened for risk of persecution, risk of trafficking, and their willingness to return voluntarily to their country. But it really doesn't matter whether these children have been living in the United States for months or years or hours. I saw a young man who was 17 years old, turned around and sent right back when he had just graduated from high school in Brownsville, Texas, and had lived in Brownsville for many, many years. He was turned around and sent back, and he was told, "Don't worry, you'll be able to come back soon," which was a complete lie. He was not able to come back. He had no way to come back that anyone realized until many, many months later. So children from Mexico, because we don't really see children from Canada on the southwest border, are generally turned around and returned to their countries through the Mexican consulates within a matter of hours, no more than 24 hours. Children from non-contiguous countries, so that could be Central America or anywhere else in the world, are placed into the shelters of the Office of Refugee Resettlement. They have the right to go to immigration court, be placed in removal proceedings, and the majority of those children are reunified with family and friends within about 20 to 30 days. It could be 7 days, it could be 20 days, it just depends on the case. So they're released and they move into their communities. Their cases are prioritized. They've been receiving hearings within 21 days of reaching those homes. But then Aryah, I think, is going to take it from there and talk about what happens to them further.
Thank you very much, Meredith. My name's Aryah Summers. I'm Director of Advocacy at Kids in Need of Defense. And I'm going to be picking up on a piece that Meredith introduced us to, which is expedited removal. And I'm going to be talking about something called the removal proceeding and why we advocate for it and what do we advocate for in the context of a removal proceeding. So in just a few clarifying points, I'll be talking about unaccompanied children, which under our US laws are defined as unaccompanied alien children under the age of 18 who don't have lawful status and do not have a parent or legal guardian with them at the time of apprehension. And I will also be referencing families. In a lot of the memorandum that you might see by the US government, you'll see them referred to as adults with children, but those are families. So I'll be referencing them as families. And I also want to note that some of the key advocacy issues that I'll be addressing are not new. These are advocacy issues we've been working on for decades, streaming all the way back to the 90s when there was significant litigation, also in response to a Central American influx of refugees. So it's an interesting historical note. And also terminology. As immigration, I'm an immigration attorney, I'm a children's attorney, that's my background. So I tend to use a lot of legal jargon and terminology, so please ask at the end if you have any clarifications. In my particular presentation, I'll be talking about the removal proceeding. You'll also hear it referred to as a deportation proceeding. Some of the language has changed over time, particularly since 1996. So sometimes it's confusing. You'll hear expedited removal and a removal proceeding. So I'll do my best to be clear on those distinctions. And you'll see it also referenced sort of in newspapers and news releases about removal or deportation. So what is a removal proceeding? How is it different from what Meredith was addressing? So a removal proceeding is an actual process that happens before the Executive Office for Immigration Review, which is part of our US Department of Justice. And so it's a civil administrative proceeding. It is not a criminal proceeding. And at that proceeding, an immigration judge is presiding over a case. And there is an attorney from the US Department of Homeland Security, the Immigration and Customs Enforcement section, who represents the government's interest in demonstrating that a person is not lawfully present in the United States and they're seeking their removal from the United States, which is why we call it a removal proceeding, or seeking their deportation from the United States. And we also have the individual, so the respondent who's in the proceeding. Interestingly, in our immigration court system, the respondent or the individual, even if they're a child, do not have an attorney that is appointed to represent them. So most of us are familiar with a system where there are attorneys appointed for children in many different contexts, in our juvenile justice system, in our child welfare system, but in our immigration court system, there's no attorney appointed. So children and families as well go into the proceeding without an attorney with them in many cases. It's the importance of that later. In addition, there may be an interpreter, of course, because a lot of the respondents do not speak English and they need interpreters to help them understand what's happening during the proceeding. An immigration removal proceeding is the same for children and adults. There is no special children's court. They're exactly the same. So I think that's an important piece to keep in mind. So what happens during a removal proceeding? So the Immigration and Customs Enforcement attorney will present evidence that a person is not lawfully present, and then the person has an opportunity to present a defense to explain why they should have the right to remain in the United States. So for children and families, a lot of those ways to remain lawfully in the United States are forms of humanitarian relief. One of the most important is asylum. And this was particularly demonstrated during the surge, where we saw a large number of children and families coming to the United States seeking asylum. And many of you may be familiar with the Children on the Run report, which was issued by the United Nations High Commissioner for Refugees. I had the opportunity to work on that report before I joined KIND. And we found that at least 58% of the children cited reasons related to violence in their home life or related to gang and cartel violence as motivating them to flee their countries. And they really became commodities for smugglers. it wasn't because a smuggler offered an option, it's that they took advantage of people and exploited their reasons in order to smuggle them through Mexico into the United States. So I think that's really important to keep in mind. At the end of a hearing, so if you can imagine, the ICE attorney presents the evidence, and then the child or the family have to present their case. They're supposed to collect evidence, present witnesses, be subject to cross-examination. There's a whole process, and they're supposed to navigate this on their own. And at the end, the immigration judge makes a decision to either grant the humanitarian relief or to deport the person. And so once that decision's made, then the process begins to remove them to their country of origin, or they are then granted lawful status in the United States. It's important to note that for children, there is no best interest standard in an immigration court proceeding. So in contrast to some of our other systems like child welfare, where best interest is a guiding principle, this is not a standard in our immigration court proceeding. And we also do not have any special provisions for safe repatriation or reintegration. So even if the judge believes that it's not in the child's best interest to be returned, or they cannot be safely repatriated or reintegrated, he or she may still have to deport that child. And so that's something to keep in mind, because there are only certain forms of relief that will apply to children and families. So why is it that we see the removal proceeding as so important? It doesn't sound it sounds like a very challenging process. So why do we fight for it? And I think, Meredith's presentation really demonstrated this point very well, is that we're seeing a sort of detention and deportation factory process emerge. And that means that people do not have a chance to have their voices heard in a process. And what the removal proceeding does is it gives an individual a chance to tell their story to a judge, and for the judge to apply criteria. There can be evidence presented, there can be psychological affidavits. There's a much better opportunity to protect and provide that person a space to tell their story. Whether they qualify or not is ultimately established by our US immigration laws, but to have that opportunity to tell their story is the most critical point that we fight for. That's what we call due process. And we fight for that in many of our, all of our American justice systems are based on a concept of due process. So I think that's why, we fight for a removal proceeding despite some of the challenges that I've identified. And in a removal proceeding, you have a record of proceeding, you have an opportunity to appeal the decision. So if the judge, despite hearing your evidence, decides that you're not eligible, you can still appeal the decision. And so there's really a process in place, and we feel that that best serves children and families, particularly in situations where they're seeking humanitarian protection. And as Meredith noted, there is a distinction. So all Central American children at this time have access to a removal proceeding hearing, and we view that as very critical. And for many years, we have fought for Mexican children to have equal access, and we have not yet been able to obtain that. But we believe that all children should have access, and those that are seeking relief, all vulnerable populations, should have access to a removal hearing to make those determinations. So some of the statistics that Meredith had mentioned at the beginning, in 2013, 70% were deported at the border in an expedited removal hearing, which is not the same as a removal proceeding. So there was no judge presiding over those cases. They did not have an opportunity to present evidence and bring witnesses and tell their full story. And to us, that's a really critical due process issue that we advocate for those families and those people at the border to have that opportunity. So what has happened to families and children after the surge of last summer, where we all became alerted to the situation that many of us had been working on for many years, and we were telling our colleagues, something is coming. There is a buildup of people seeking protection, and something critical is going to happen, and it happened last summer. And what we found is that after the surge, the response has created even more challenges for us. So in the context of the removal proceeding, there has been an effort to expedite the hearings, to move them faster. So what that means is that children have to disclose things quickly. And if any of you have worked with children or anyone who has suffered trauma, you know that it doesn't quite work that way. And you have to build trust, and you have to gain the confidence of that person to be able to represent them and present their information. And I think, imagine for yourself trying to describe the most painful and terrifying details of your own life in an immigration court proceeding, and how important it is for you to understand what your rights are and someone to help you navigate the process. And so this expedited process that has been touted as a benefit has actually been a huge detriment to our access to lawyers. So a lot of the children don't have time, families don't have time to find lawyers. There's not sufficient time to build a case because asylum law is very complex. We're coming up on tax season. Tax law is very complex. A lot of people compare immigration laws to tax laws. There's many nuances. It's a deeply personal process because you have to talk about a lot of difficult experiences. So this expedited removal process is very concerning to us as advocates. And for families, many of them continue to be held in the detention facilities. So even if they're not in an expedited removal process, they're actually going before an immigration judge, they might still be held in a detention center. And what that does to someone psychologically is very detrimental to their case, their will to fight. So it's very hard for a mother with an infant to sit in a detention center and try to fight a case where they may have suffered rape or some very severe form of violence in their home country, and they're sitting in detention. And so we're very concerned that those conditions are deterring people, families from actually seeking the protection that they may be eligible for. So what are our key areas for advocacy in this context? First and foremost, we advocate for legal representation for all children in vulnerable populations. So we believe that children and families should have access to attorneys to help present their cases. And currently, more than 70% of unaccompanied children do not have attorneys to represent them. But children are 5 times more likely to succeed if they have attorneys representing them. So what does Kids in Need of Defense, and many of my colleagues, there are some in the room today and others who do this work across the country, what is it that we advocate for? So we advocate for a public-private partnership that combines both direct representation models, which are appointed attorneys, together with leveraging pro bono resources from our law firms, our corporate counsel departments, our private practitioners, to leverage that to increase access and actually guarantee counsel for children in removal proceedings. So that's one of our key areas. The second is due process. We believe that there should be due process for children and families, and that they should not be in expedited proceedings. Third, we advocate for the appointment of child advocates are sort of conceptually like a guardian ad litem in a child welfare proceeding, and their goal is to watch out for the best interests of the child. So having a child advocate present in a case, in a removal proceeding, gives the judge an opportunity to hear about the best interests of that child as well, in order to take that into consideration in the judge's decision. Next, we advocate for safe repatriation and reintegration. So we as the US do deport children and families back to their countries of origin. The numbers have shifted over the years from several, usually around 500 to 800 children that we've counted to Central America. And the US process for repatriation, it's essentially a process where they hand over the child to a government entity of origin, but that's where the process stops. There's no follow-on. There's no guarantee that the child safely returns home. We did not have any information about what happens to them. And so KIND has a safe repatriation project in Guatemala, where we have worked with about 121 children since October of 2010 to help safely repatriate them. I do want to make clear that this repatriation program is voluntary, so the child has to consent. It is also about building local capacity. So KIND has partners on the ground who have experience working in country. They understand the social dynamics, the dynamics of violence, the opportunities for children that exist or don't exist. And so our model is built on strengthening and working collaboratively at the local level. And what we have found is that, and the third point I want to make is that children in this program have already gone through a due process. So they have already been through a removal proceeding, and they have either lost their case and they are being ordered deported, or they are voluntarily asking for removal. So I think that's important to remember. It's not a program that all children are subject to. It's a program that they volunteer for, and that only kicks in has gone through a due process hearing. And I'm happy to answer more questions. I know there were some earlier questions about more details about the programs. I'd be happy to discuss those during Q&A. And finally, child-appropriate immigration courts. We believe that the immigration courts and the judges should receive more extensive training on child protection principles to ensure that these are implemented not just procedurally, but substantively as well. Thank you very much.
Well, hi, my name is Wendy Cervantes. I first want to thank the Red Cross for inviting me to be here today. I'm very happy to be part of this panel. For those, I'm the Vice President of Immigration and Child Rights Policy at First Focus, and also the Director for our Center for the Children of Immigrants. And for those of you who aren't familiar with First Focus, we're a national bipartisan children's advocacy organization based here in DC. And we're one of the only mainstream children's groups that also focuses on immigration as part of our policy work. And so our Center for the Children of Immigrants focuses on the unique ways that federal policies impact children and immigrant families. And this includes our immigration laws as well as our enforcement policies. So we focus on unaccompanied children as well as dreamers, undocumented youth growing up here in the US, as well as children broadly in immigrant families, including US citizen children. So I'm going to follow up on my co-panelists have done a great job discussing some of the issues on the border and also what happens to children and families once they are going through the removal proceeding process. So I'm going to shift a bit to another topic related to family unity and really looking at the 11 million undocumented immigrants currently residing in the US. So as many of you know, children and immigrant families actually comprise nearly 1 in 4 of all children in the US and are one of the fastest growing segments of the US child population. They're contributing to this demographic shift that we always hear about in terms of the US changing demographics. We also know that about 5.5 million children, the vast majority of whom are US citizens, are currently living in what we call a mixed status family with at least one or more undocumented parent. And unfortunately, due to the lack of passage of immigration reform in recent years, we know that children have really paid a heavy price and have had their lives turned upside down due to record level deportations. For example, we know that in 2013 alone, DHS deported more than 72,000 parents of US citizen children. And a report by Human Impact Partners estimates that in just 1 year, more than 150,000 US citizen children were directly impacted by a parent's deportation. It's also estimated that more than 5,000 children have been unnecessarily trapped in our state child welfare system due both to immigration enforcement laws, but also child welfare system policies that actually disadvantage undocumented families. So as a children's advocacy group, we've spent a lot of time looking at the many ways that immigration enforcement hurts children. And it's no surprise that several studies focused on this topic have shown that when a parent is detained or deported, or even the fear itself of having a parent detained or deported has serious impacts on a child's health, mental health, and their economic security, including high rates of post-traumatic stress disorder, crowded housing situations, inadequate access to food, and more, all of which tend to be due to high stress levels, as well as that sudden loss of parental income once a deportation has happened, and all which alone can increase a child's chance of falling into poverty, having poor outcomes overall, or becoming involved in our child welfare system. So this is one of the many reasons why the president's recent announcement on immigration executive action is so important, because we know that the new programs have the potential to make a big difference in the lives of millions of children and families by finally lifting this fear of deportation. Together, and I'll talk just really briefly about the new programs, These programs have the potential to reach around 4 million individuals by providing them with 3 years of renewable deferred action or relief from deportation, and the opportunity to qualify for a work permit. The 2 new programs include an expansion of the 2012 Deferred Action for Childhood Arrivals program for immigrants who entered the U.S. before the age of 16, also known as commonly referred to as Dreamers. The old directive in 2012 actually had an age limit. You had to be under 31 at the time of application, but the new program actually eliminates that age cap and changes the date required for of required presence to open it up to more individuals, so more people will be able to apply. And then there's a new Deferred Action for Parental Accountability program for immigrants, U.S. citizen or legal permanent residents, and who have resided in the U.S. for 5 years or more. And so this will get at that issue of U.S. citizen children who have undocumented parents. And in addition to the deferred action programs, there are also other changes to immigration laws that will to the immigration system that will help keep families together. And I'll only talk about one for purposes of time. But for example, there is something known as the provisional unlawful presence waiver that's to be expanded to allow certain individuals who have been unlawfully present in the U.S. for more than 180 days to apply for a waiver to overcome these reentry bars, which my colleague spoke about a little bit about what those are, where you can't re-enter for a certain number of years, that would force them to be separated from family members while they're waiting to apply for an immigrant visa. Right now, individuals who apply for a re-entry waiver must leave the country and apply from abroad and wait for approval, meaning that they may be forced to wait several years to be reunited with a family member, and it's not clear if they'll be granted that waiver. So the new waivers actually allow eligible applicants to apply stateside while they're here in the U.S., and they only have to leave the country once they're assigned an interview at a consulate abroad. The new program will be expanded to the sons and daughters of U.S. citizens regardless of the son's or daughter's age, as well as the spouses, sons, and daughters of lawfully permanent residents. Previously, when this waiver was announced in 2013, it was only available to the immediate relatives of U.S. citizens. Also, the definition of extreme hardship for the purposes of qualifying for this waiver will allow to further streamline the process. And all of this will help minimize the amount of time that families are separated as they wait for the approval of their visa. So shortly after these immigration actions were announced, the First Focus Center for the Children of Immigrants released an analysis entitled A Step Forward, Immigration Executive Actions in Our Nation's Children. And I believe this was shared via the materials for the conference. In this analysis, we highlight the various ways that these actions are going to help families, which of course includes removing that fear of deportation, but we also touch on ways that these programs can help families do better overall. So for example, we know that more than 600,000 youth have already obtained relief from the DACA program since 2012, and research shows that the program has had really significant results for those who have benefited. For example, we know that more than 70% of DACA beneficiaries have been able to secure. More than 60% have obtained a driver's license, and more than half have opened their first bank account. These are real life changes for people who have applied, and many of these young people have also had improved access to higher education, both because now through work permits, they're able to help pay for college and also have expanded access to in-state tuition in states that allow them to access in-state tuition. So likewise, for parents who are able to benefit from the new DAPA, Deferred Action for Parental Accountability program, the benefits to their children could also be incredibly beneficial. It's no surprise that currently children of undocumented parents are more likely to live below the poverty line. And this is understandable because undocumented parents are obviously less likely to secure a living wage and to be able to secure it. And their children are also less likely to participate in many of the safety net programs that are designed to help low-income children and families, like the Supplemental Nutrition Assistance Program, or formerly known as the food stamp program. And the reasons why kids are less likely to participate in these programs when they live in mixed status families is for a variety of reasons. There's very confusing eligibility rules about these programs, and there's also the common fear among undocumented parents to approach government agencies. So now with access to work authorization, it's our hope that parents will be able to secure better employment, which means they'll be better able to meet their children's needs, but they'll be able to be parents. You know, like a lot of undocumented parents have had to work multiple jobs in order to make ends meet. By being able to secure better employment, they'll be better able to support their child's education, help with homework, and that means children will do better in school and just do better overall. And so it's very important that we protect these programs. It's also important that individuals apply. And the extent to which individuals can benefit from these programs is also going to be impacted by state level advocacy efforts and state legislation that will make these programs available to driver's license and other things. And I'm getting a 2-minute warning, so I'm going to wrap up pretty quickly. But I just wanted to point out that it's also important to note that these programs have limitations and they won't cover the full 11 million. There are still parents who won't qualify, including parents of U.S. citizens or lawfully permanent residents who have been here for less than 5 years, parents of dreamers who don't also have a U.S. citizen or lawfully permanent resident child. And it will also do nothing for those parents who have already been deported and who would have qualified for relief if they had still been here. And also these programs are only temporary and don't provide any formal immigration status or path to citizenship. Now, I just want to say that over the next 2 years, we'll need to focus on a couple of different critical areas. One, we'll need to defend these administrative actions, and I say this as today the House of Representatives is voting to defund these programs and prevent them from being implemented. Second, in addition to defending the programs, we'll need to continue to defend all those family members who don't qualify under these programs and to make sure that their family unity and child well-being is being considered in decisions about deporting parents who maybe don't qualify for these programs. We also need to continue to defend the rights of new immigrants, and that includes the unaccompanied children and families that are continuing to arrive here. I think it's important to note that the new administrative actions explicitly target recent entries, which would include unaccompanied children and families that are continuing to arrive here for priorities for removal. And finally, in order to get a long-term permanent fix, it's also going to be vital to continue to push reform. One that includes path to citizenship, legal representation for unaccompanied children, and also the possibility for parents to return to the U.S. if they have already been deported, but they have children continuing to reside here. And this is actually a provision that was included in the bipartisan Senate bill that passed in 2013, a viable option that has had bipartisan support in the past. And I just want to say one quick thing is that immigration relief is only part of the picture. We also need to be pushing for policies that will help immigrant children and families thrive. Right now, too many of our U.S. child-focused policies around things like early childhood education programs, healthcare coverage, nutrition supports, income supports, and other public benefits actually create barriers for immigrant children and families, including those who are here lawfully. So we expect to see a lot of attacks on eligibility for these programs in the coming years. So I think in addition to ensuring that immigrant kids and families have access to the safety nets and resources they need, we also need to make sure that the systems that serve them are able to serve them effectively and in a culturally competent way. And I would say that this also applies to not just families in the U.S., but also to children who have been deported, who have been deported, but also children who have gone back with their parents who have been deported. We have a lot of U.S. citizen children living abroad with parents who have been removed, and we need to be working together with Mexico and Guatemala and other countries to make sure that kids in those countries are also getting access to the resources and programs that they need. And with that, I'll turn it over to Ashley.
Thank you, Wendy. Hello, my name is Ashley Feasley, and I'm the Immigration Policy Advisor for the U.S. Conference of Catholic Bishops. I work in Migration and Refugee Services Department at the conference, and IMRES works to serve unaccompanied children, refugees, trafficking victims, and work on comprehensive immigration reform. First off, I'd like to say thank you so much to the Red Cross for organizing this panel and hosting this wonderful conference and inviting the Bishops' Conference to participate. We appreciate the opportunity to speak on such important issues. I'm going to pick up a theme that some of my fellow panelists talked about, and that is family detention and the rise of family detention in what has been a world. Basically, one of the reasons why we're going to speak about this is because the bishops themselves have taken a lead role in advocating for the end of family detention. In their work with the migrant communities in their parishes and also in the criminal justice context. It's important when we talk about this particular issue to see where we are. While the influx of unaccompanied migrant children this summer received extensive media attention that we all are aware of, what wasn't captured by the television crews or nearly as reported on was the equal number of immigrant families, migrant families who are coming across the southwest border. My colleague Meredith mentioned the number. An equal number of migrant family members, around 68,000, came as children. But while some of the unaccompanied children were able to reunify with their families while they are working on the pendency of their immigration case, many of these family members, these young women with their children, received much more severe and harsh consequences. Some of these people, they were detained in detention facilities, and in reality, they have become the newest addition to the sprawling National Immigrant Detention Industrial Complex, which is what we have here today. In the last 6 months, this is really the reality on the ground in terms of family detention. This summer, in response to the rise of the increased numbers at the border, ICE, the Immigration and Customs Enforcement Office, rapidly expanded its capacity from approximately 90 beds in April 2014. That's what ICE had to house family members. That was in Berks, Pennsylvania facility, to 1,300 beds by mid-August. Right now, we're at 3,000 beds capacity with plans and signaled intentions to scale that up to 6,350 beds in the near future. Large-scale family detentions have been stood up in Dilley and Carnes, as my colleagues have mentioned, and another temporary facility that was on a federal law enforcement training ground in remote Artesia, New Mexico, has already been opened and closed. Just as for a fact, the average age of children at that facility in Artesia was 6.5. They were 6.5 years old. It's worth noting that both the Texas facilities that we have seen open, the large-scale facilities in the past few months, have been operated and opened through agreements with for-profit private prison corporations. I also note that in general, as a policy with family detention, this was a policy that the administration itself in 2009 ended from the previous administration with quite a bit of press and positive attention when they closed the Hutto facility in Texas, which was a large-scale facility that many advocates are aware of, had received a lot of criticism. In addition to quickly standing up the family detention facilities, the administration, as Wendy has mentioned, has signaled that most likely family detention is here to stay in one form or another for the foreseeable future. They expressly mentioned that there was no relief included for this population in the November 20th executive action. There's a panel and I will address a lot of the particulars of this issue, so I will not do a deep dive here. But the background I provide about the state of family detention is necessary because while many of us work in the room on this issue and may be aware of family detention, the reality is the larger public, they do not know about this and they have not been made aware. And as such, we must work harder to educate and engage our communities on this issue. While the bishops themselves recognize the need for immigrant detention in certain contexts, they are deeply worried about the growth of family detention. Young mothers and children fleeing violence who are being detained in prison-like facilities are a population of great concern, and as such, USCCB advocates for the end of family detention. While I make this about what is needed in terms of driving advocacy on this issue, these points I think can definitely be applied to many of the topics that have been discussed here, such as the need for comprehensive reform and the care and legal service representation for unaccompanied children. First, we must talk about root causes and why these women and children are coming. The larger public still is not aware of the horrors that these families face and why they were traveling such dangerous and long journeys to come here. We must highlight that these women are largely coming for protection reasons. Simply, they are frantic to escape violence. Second, in expressing those root causes and some of the issues, we must better articulate that detention of this population will not be an effective deterrent strategy, given why these women are coming and what they are fleeing. This is building on the first principle of the issue of root causes. We must articulate to policymakers that the fear that these women have of remaining at home is greater than the fear of the journey that they have or what happens to them here in the United States. To this point, I'm reminded of a young mother who I met at a repatriation center in El Salvador when I went on the 2013 Bishops delegation. When she was informed of, asked about the dangers and why she chose to continue trying, she said that she would rather die trying on the journey than face. These were such simple and jarring words, and I think that they convey what we need to convey to policymakers about the fact that this is not an effective deterrent strategy. Next, we need to make the case that family detention is harmful to children's developments, period. This needs to be a point that there's no way to sugarcoat, and we need health advocates, mental health, those in child welfare experts to come and step up from a health perspective as well, because the message is not reaching where it needs to be. Fourth, in addition to advocating for the end of this system, we must offer humane and practical solutions and alternatives. Policymakers, I think at the end of the day, they know that this is a problematic system, but I don't know if they have the solutions before them. As advocates, we must utilize our respective expertise and offer meaningful policy alternatives to the current system. These alternatives can be in the form of programming, such as community-sponsored alternative to detention pilots, or they can mean increasing access to mental health and language services and providing childcare services within the facility. The important point on this is that we must come ready to give solutions that are trauma-informed and also cost and pragmatically viable. To this end, the U.S. Conference of Catholic Bishops Alternative to Detention pilot program in cooperation with ICE currently. We currently work in Boston and Baton Rouge. This is a program that's not directed specifically at this time towards families, but is moving towards the option of doing that. In addition to this program, we are advocating for community-sponsored case management programs that address the needs that this unique and vulnerable population have in a much more cost-effective manner than some of the costs that were mentioned here. Again, $164 a night, there's got to be a better way. And many of us here have the answer. Lastly, and probably most importantly, we really need to make a human connection on this issue. This goes back to the first point I think about root causes, and in a way, we need to make these women and children human to the larger American public, and we need to tell their stories. I know that there was a lot of effort with this summer with the children and talking about the narrative of the violence that they fled. And I think for these women, because some of them, they're not children, they're adults, there's a little bit more of a divide. I think this is important, to really make the connection. I think for the big point of this is how are we going to do that? Well, the answer is varied, right? There is no one clear answer, but I believe making it personal affects a different type of narrative for all of us, bringing what we bring to the table. For the bishops, for example, it's the intersection of faith and the tenets of compassion and dignity. For some in the criminal justice world, in the criminal justice context, it's the build-up of the criminal justice infrastructure as we know it in the United States. For some, this may be the issue of a community perspective. It could be anger at having such a facility in your backyard, in your neighborhood. For others, it could be a fiscal policy issue, right? The extreme costs to taxpayers when there are more humane and cheaper alternatives available. The point is we must make this personal and immediate because this is moving forward and we have got to draw more attention to what is going on. The bishops themselves connect on this level. Several bishops and archbishops have spoken out on this issue, and archdioceses, such as the one in Seattle, have held vigils in honors of family detainees. Parishes have stood up visitation and pastoral care groups, and volunteers have sent detained children cards and presents relating to Christmas and birthdays. We, as a Catholic network, have sent over 25,000 postcards to the White House and Congress, and USCCB will be issuing forthcoming a detention report this spring that addresses family detention. Yet simply more needs to be done because so many do not understand what it is that, is going on in these facilities, how these women, young women with children are being treated. I have a personal story from when I went to Artesia, New Mexico, the facility there, with the ICE NGO working group. We were divided into groups and allowed to tour the facility. And there were children with their mothers all over. And it was very hot outside. It's New Mexico in July. And there was a small child with her mother, and she was wearing a sweater. And she was sweating, and she was very hot. And when she was asked about why it was that she wouldn't take off the sweater, she responded that this was her favorite sweater, and that she was worried she would lose it if she didn't wear it. And it was such a small little side to what we were being given as our tour and what we were hearing about the facility, but it was such a personal anecdote that talked about the vulnerability of these children and what they have faced and what their mothers are dealing with in their care every day, that I think that we all need to find a way to convey to lawmakers how important this is, what a vulnerable population this is, and how family detention is not a good facility. Lastly, I will say that the Archbishop of San Antonio, who houses both Dilley and Carnes in his diocese, on the day of the Dilley opening, I think he most prophetically talked about what this was in terms of a faith perspective. Of Dilley, he said, "It is the largest facility of its kind, and some have called it history making. That forces me to ask, what kind of history does our country want to make? Will our history be defined by the detention of children and their mothers who do not threaten us with either violence or security risks? They need mercy and compassion, not derision and detention." Thank you so much, and I'm more than happy to answer questions, and I look forward. Thank you.
Thank you, Meredith, Aryah, and Wendy, and Ashley. Those are fabulous and presentations, really thought-provoking ideas. And we started a little late, so I'm going to take a little bit of liberty here, and we'll go about another 10 or 15 minutes and answer questions. So who would like to ask some questions here? What can we do as individuals to advocate for less detention of kids and families? Are there specific calls to action? Well, this isn't working. I'm sorry.
No.
Okay, so I'll say that again. What can we do as individuals to advocate for less detention and of kids and then families, and then what are some specific calls to action? I think some of that Ashley talked about, but I'll also ask the other three panelists to add to their comments.
Thanks. One of the things I would say is right now we're in the middle of the Department of Homeland Security appropriations bill, which, some who do, direct service may not kind of be as familiar with, but some of the issues relating to this is how the department will be funded. For a long time, there's been a provision about alternatives to detention programming, yet a lot of that money is diverted to ICE's alternatives to detention programming, which are ankle bracelets, sometimes monitoring system. We are advocating for more funding for community-sponsored alternatives to detention program that utilize more of a case management model. The other thing we're asking for pressure on the administration to end this policy and some administrative advocacy, and I'm sure my other colleagues can continue, particularly on the legal services.
One thing I'll just quickly add is that obviously for folks who aren't lobbying in the Hill every day, yes, it's helpful to reach out to your representative and make it clear that this is something that's really important. I think it's important because a lot of folks might also just applaud these administrative actions that are going to be incredibly helpful, but also there's a need to push back at the same time on this practice of family detention. I also went with Ashley on that tour in Artesia and was very, as a child advocate, appalled at the condition, at how bad of a system this is for children and what it does to the parent-child relationship and a child's mental health. But the other thing I was going to say is that it's important to spread the word. Op-eds at the local level, I think, are really helpful because unless you're in one of the areas where there is one of these centers, a lot of people just really don't know that it's happening and to the scale that it's happening.
And I would just reiterate the point of putting pressure on the administration There are a number of working groups that some of us are involved with here in DC that if your organization is interested in becoming involved with, it'd be very helpful to have the mental health and child welfare perspectives better represented. I think another key piece is sexual and gender-based violence, domestic violence survivor groups. We have many women and many children who are survivors of severe child abuse and domestic violence, and they are seeking protection. And I think having that voice is really critical. And then at the local level, we're all connected to local legal services organizations and social services organizations and faith-based organizations that are connected to the issue locally. So you can reach out to our organizations and find out what's happening in your city that you can be involved with directly.
I think it's important to reach out to your federal lawmakers, and obviously the humanitarian arguments are very important and compelling, and the individual stories, but it's also very compelling to talk about the fiscal impacts, taxpayers to be detaining these families for the amount of time it takes to hear their cases and adjudicate their cases fully. A lot of these families are not receiving, or at least in the summer months, we're not receiving bonds. ICE was opposing bonds for these families. I think that things have eased up somewhat at this point, but it really is a case-by-case determination and judge by judge. And so focusing on the fiscal arguments and cost to taxpayers is important.
Thanks. Let me take one more room here. I think the mental health provider sort of specific stuff Aryah already covered. Given the current situation with expedited proceedings, is there any stopgap measures to ensure representation is provided, particularly to children?
Unaccompanied children are not subject to expedited removal proceedings, but accompanied children are. And so there is the legal orientation program that's funded through the Department of Justice and the Executive Office for Immigration Review that provides legal information and pro se assistance and some pro bono assistance to people who are in removal proceedings. It may also be applied to people who are going through the expedited removal proceedings, but really that process is so quick, like I was talking about. It may be a matter of days that often the providers, the legal service providers that work in the detention facilities are not able to reach those people. And so that is a real concern. And we have been advocating for increasing funding for the legal orientation program so that more people will benefit from it.
And in the context of the removal proceeding, I did speak about sort of the faster pace, which I didn't want to cause any confusion with the use of the word expedited, but it's that the removal proceeding is happening at a much faster rate, so it doesn't give people time to find attorneys. And so there are measures that we can take. One of the things that we're seeing happening is that children are receiving in absentia orders because they don't receive notice of the hearing, or they do show up to the hearing, but they don't have representation and they're ordered deported, but they haven't had a chance to articulate a claim. And so in those cases, there are measures that we can take. Even if a lawyer doesn't accompany them, there are other measures we could take to accompany and make visible that process and let the judges know that we're watching and this child needs more time to find an attorney. And there are resources, so there are community-based resources we can try to leverage to help accompany people to make the problem visible. We also are working with EOIR to try to slow down the pace of hearings and return to our pre-surge system. Hearings were being set sometimes 7 days out, not enough time for a child to find an attorney. So we're asking for there's an existing memorandum called OPPM 0701. It's a technical memorandum from EOIR where there are specific guidelines on these cases being exempt from case completion, which is this is very technical, but there are just places where we can add does not need to fasten the pace of the hearings, that it actually serves their interest to not do that. Because if you do it in absentia, then you have to do a motion to reopen. It's a lot more resources for the judges and for the system for us to have to go back in and reopen all of these cases.
Thank you. In the room? Oh,
Thank you. This question is for Aryah. And Aryah, during your presentation, you mentioned that for children to be repatriated back to their country of origin, they'll have to agree to be repatriated. So what happens if they don't agree to be repatriated? And what is the difference between repatriation and deportation?
Very good question. Thank you. So what's interesting is if we look at the international context of how repatriation works, it's usually a decision that happens not in the context of a deportation proceeding. And so a repatriation process is actually analyzing the child's best interests, trying to determine with whom they'll receive the best care, the greatest protection. So what's different is that in our context, repatriation comes after a deportation hearing has happened. So the repatriation considerations usually don't form part of the deportation hearing. And so when I say that a child volunteers for a program, they may not have agreed to be deported. So the child may not want to go home. And those are some of our most challenging cases because psychologically, it's very traumatic for a child to be forced back against their will. And so our program works with some children who've been ordered deported who have lost their cases and did not want to return. And those are very challenging, particularly if it was a loss related to because they had a fear of return. So we have had children that have lost their cases, have lost their appeals, and they're being deported. And they're going back to situations that are unsafe. And those are the cases that we're most concerned about. We don't believe those children should be repatriated, but the system doesn't allow them to stay. So I just want to make that clarifying point. And actually, as a point of advocacy, we do believe that repatriation considerations should be part of the deportation hearing. So if you think about it analogously in our child welfare system, we would never force a child to go to a home that hadn't been looked into, that no one had looked at where they're going to go to school. Do they have sufficient food and clothing there? Are they protected there? Are they safe from violence? How does the child, him or herself, feel? We would do a whole analysis. We would never force that child back into a situation against their will or without looking at any of this. And so it also, work interest standard, which we don't have, but it's something that we believe should happen in a case. And it's true not just for unaccompanied children, but for children with families and for parents who are in deportation where their children are here. We should look at the best interests of those children as well and the impact of the loss of a parent. And so I think it's a very important question because it helps clarify that piece. And there are some children who have voluntarily decided to return for any number of reasons. And we always have an opportunity to go back and make sure that their rights, the due process rights, were respected. And if the child truly is returning voluntarily, that creates other opportunities for us when we work on the reception and reintegration side within Guatemala.
There's a new question. Question number 2.
What kind of discretion do authorities have when an adult or a family are apprehended within 100 miles of the border and within 14 days? If they don't express fear of return, are they all put into an expedited removal process?
It may depend where they come from. Generally they are, but I've seen cases, for example, families from Eritrea or Ethiopia, Somalia, where they know they're gonna most likely pass a credible fear interview and they'll place them straight into removal proceedings. But generally they are placed in expedited in that time period.
Another question.
I'll tell you what, I'm going to have to take the liberty of asking the last question only because we're running out of time. We're already into lunch. But what I want to do is I want to give each of you all have given a wealth of advocacy topics and advocacy agendas and things that people could wrap their arms around and try to do. But I'd like you to take all of these things we've heard and each one of you give me your number one priority. If you had one item that you had to advocate on, you had to insist that someone made a decision on and was going to make a policy change for the better on these issues, what would that one thing be?
Give me a second. I mean, number one, maybe we could just say one thing that's a priority, not the number one thing.
That's what I'm getting at, the priority issue.
I obviously ending family detention and advocating for the end of family detention and for these women and children to be screened and placed in more cost-effective and more humane community-sponsored alternatives to detention programs.
I would say immigration reform, because that's the long-term permanent fix for families here, and also to fix the immigration system so we don't have horrible things like family detention happening.
I would have to say appointment of counsel for children in vulnerable populations to ensure that they have an opportunity to present their cases and be heard in a fair and just way.
That's what I was gonna say. But after that, I think the end of summary removal proceedings, which would include expedited removal, reinstatement of removal, administrative removal, expedited removal of non-LPRs, all of those proceedings, and let everyone go before a neutral judge.
Thank you all, and join me in thanking them for outstanding. On the spot there, but I think there's such a rich amount of information, and I think it's just, you all really hit some good high points here on what would be the priority. Now, Kathleen or Liz, can you tell us what's the lunch plan?
Yeah. So we're gonna break for lunch now, and I know we're a little bit over, so we'll probably come back around, I think actually around 1 o'clock.
Sorry. So for lunches, if you're a vegetarian, come see Kathleen Selinek to, or come see me if you're a vegetarian. There are not lunches out there for vegetarians, but we do have alternative. Thanks.
Thanks, Lisa.
Oh.
Thank you. Thank you very much.